the avoidance and resolution of boardroom and employment disputes in the new normal. This topic comes into focus, particularly as we head out of the furlough scheme and businesses adjust to the current economic climate. We have three mediators to speak this morning who are very experienced in the field to explore different aspects of this topic. Before introducing our speakers, a couple of admin points, if I may. We are keen for your participation in the webinar. There will be 15 minutes for questions and answers at the end, and you can raise these by chat, Q&As, or raised hand features on Zoom. We will also be running polls with a couple of questions to you, so please do join in. Our first speaker this morning is Chambers member Anthony Fincham. Anthony is a highly experienced mediator who was until recently a partner at a leading London law firm. Anthony specialises in workplace dispute resolution and has mediated in a range of other types of disputes. He is going to tackle the issue of how to go about making redundancies and will also give some guidance on workplace mediation. So Anthony, over to you.
Thank you, Tony. Well, good morning, everybody. I may add this word of welcome to the webinar. As Tony said, for all too obvious reasons, we thought it'd be helpful to start with a short recap on making redundancies. And that really comes down to two things. One is, do you need to engage in collective consultation with employee representatives, be it a recognized union or elected representatives? And the answer is yes, where the employer proposes to make 20 or more people redundant within a space of 90 days at one establishment. And the obligation is to consult in good time and at least 30 days before the first termination, 45 days if the number is 100 people being made redundant. The penalty for failure to consult is a protective award of up to 90 days actual pay for each affected employee. That all sounds very straightforward. Just one or two cautionary notes. Affected employees is very widely defined. I had a case where 70 people were made redundant. There was a claim that the consultation was flawed because the information given was inaccurate. And the claim was brought for protective award for about 1,200 employees who it was said were affected by redundancy. It actually failed in the Court of Appeal, so that point wasn't tested. A second cautionary note is you have to consult in good time and not less than the 30 or 45 days. So you can't sit on a proposal and wait for the 30 or 45 day period. And then a final one is you can give notice before the consultation, notice to employees before the consultation has expired, but that runs the risk of undermining the consultation. So the other half, you need to think about individual rights of employees. Anybody with 2 years service, I'm sure you all know, can bring an unfair dismissal claim. Somebody the other day asked if I could point him to the relevant legislation on this. Well, there isn't any. It's all in case law. And what it comes down to is you need to engage in discussions with the individuals concerned. You need to have fair selection criteria which are fairly applied, and you need to make a search for suitable alternative employment within the employer's group. The award for unfair dismissal is now capped at £88,519. There are a few misconceptions, I think, about the individual rights and individual consultation. One is that you must have 3 consultation meetings. A lot of people recommend that, but there's no legal requirement. The second is that the employee is entitled to be accompanied. That's not the case, although it's fairly common practice. Third one is that you must give an employee right of appeal. there's no overriding legal entitlement to an appeal. ACAS recommend one against application of selection criteria limited to that. That said, of course, you may have a contract of employment or a staff handbook, which affords employees the right of appeal against any termination, in which case that will need to be respected. Now, the I say joker in the pack, but that's not an apt description, is discrimination of whistleblowing. Any redundancy can give rise to a discrimination claim or a claim that the decision to make somebody redundant has been wholly or mainly because he or she has blown the whistle, made a protected disclosure. And there's, first of all, no 2-year qualifying service, so these rights apply from day one. Secondly, the compensation's uncapped. And I just to illustrate that, I dealt with one redundancy whistleblowing claim which succeeded, and the individual got about £4 million. Okay, so happy obviously to pick up any questions on that at the end. Sorry it's a bit negative talking about redundancies, but I'll now move to the second half of my few words, which are some observations on workplace mediations, which I hope may be useful, might give rise to some debate. The first completely obvious point I would like to put out there is that any commercial mediations, one is used to dealing with representatives. You normally get a representative of the company, you get generally a couple of lawyer representatives for each party. Of course, in a workplace mediation, you get the actual party present, and the mediator needs self-evidently to be sensitive to that. And I attach particular importance to the opening session. I'm not particularly keen on opening sessions in commercial mediations. I often suggest to the parties they might prefer to dispense with them. You know what the issues are from the submissions, the position papers that are lodged, and I think they can be a waste of time. But by contrast, with workplace employee mediations, I think they are important, so the individual is able to say what he wants to say. Most mediation agreements give the mediator the right to call off the mediation if he thinks it's going nowhere. Don't think that's widely invoked. But I think it's something you may need to think about in an employment situation. I had one, actually with a partnership dispute, where one party asked me to convey to the other that if they didn't settle the dispute, he'd take out a contract and have the chap murdered. Well, you won't be surprised to hear that I refused to pass on that message. But I think, looking back, I probably should have called off the mediation at that point. And I was interested in observations made by Michael Cover in the first of this series of webinars that with Zoom, you can very easily postpone a mediation and reconvene it maybe a day later, perhaps half a day later, a week later. That's much more difficult when the parties all meet together. And I think that's something that is well worth considering in workplace mediations, a kind of cooling off period within the process. Another point I'm conscious of is possible conflict for the mediator. If you are appointed by an employer in a number of mediations, you may feel that your position is hard to maintain complete neutrality, maybe hoping for further referrals. And as an employee, something I would inquire is whether the mediator has done any mediations before for a particular company or other employer. And then the other situation I'd just like to address, I think I've got a few minutes to go, is where you have a situation where an employer appoints a mediator or goes to a mediator and says, can you help resolve issues between employees where you have perhaps senior people who've fallen out. The employee doesn't want to lose either of them. If matters aren't resolved, he may lose both. And then a third party neutral is instructed to see if he can help broker some sort of way forward or help the employees concerned, maybe more than two, maybe a group, to find a way forward whereby they can remain in employment and work effectively together. So you've got to ask yourself, who are the parties? Do you need a tripartite agreement between the employer and the two employees, or as I say, it may be more? Do you necessarily need an agreement with the employees that may phase them with too much legality? Maybe you can just be appointed by the employer and you don't absolutely have to have a document to which the employees are a party. Does the employer need to be present at the mediation? Will that inhibit the discussion with the assistance of the mediator between the warring parties? If the employer isn't present, what are the parameters within which the mediator operates? I mean, obviously you couldn't have the employees agreeing between themselves to double their pay or something like that, and then they live happily ever after. So clearly there's got to be some limit on what the mediator can help them to agree. And then linked with that, to whom do you owe a duty of confidence? And I think this needs to be addressed in the agreement, or if there isn't an agreement to which the employees are a party, you've got to deal with it at the start of the mediation. Can they talk to you confident that whatever they say will not go back to the employer? Are there any limits to that? Is the employer happy with that? Will that breach the terms of your retainer by the employer? Okay, so I'm throwing those points out there without offering one-size-fits-all answers. And as I say, happy to pick them up with any observations or questions at the end of the, when we get onto that section of the webinar. So that's what I'm going to say for now, and I can pass over, I think, to Jane, or do we go back to you first, Tony?
I come in now. Thank you very much, Anthony, for that short address. Our second speaker is Jane Gunn, also a member of our chambers, ArbDB. Jane has built an international reputation as mediator, conflict management consultant, and speaker, working with businesses and business leaders around the world. Jane has mediated hundreds of disputes and is frequently chosen for her extensive mediation experience, as well as her ability to handle complex or emotive cases. Jane will look at the timing for dealing with difficult employment issues. For reasons which perhaps she will explain, she is now the barefoot mediator. Jane, over to you.
Words getting around about this barefoot mediation, Tony. Thank you very much, and very nice to address everybody, although I can't see you. So I just wanted to start by saying, I wonder if you remember when you were a child being on an escalator, or perhaps trying to run up an escalator that was going down. And I want to talk a little bit about how we might de-escalate disputes, because sometimes it feels like running up an escalator that's going down. And I also want to talk about something I call the window of opportunity, because what we talk about as new normal, which is kind of people going back to work at the moment, seems to be bringing more conflict, but businesses have got fewer resources probably to waste, less time to waste than ever. And so I think, you know, we all need to rethink different ways to resolve conflict quickly. So I've been talking to a number of businesses and clients, and a call from a CEO this week who's trying to get his office back up and running again and bringing staff back to work. And these are just some of the issues that he's got, which are some redundancies to consider, some staff resistant to coming back to the office naturally, but how do you manage that? And then actually within the directors failing to agree about some of those things. So actually a conflict, if you like, or some tension at board level. And, you know, I think trying to get to grips with this new normal means that there are multiple layers of issues going on that many businesses are trying to manage as the lockdown eases. And these tensions are arising, as I say, at all these levels, you know, among staff, among partners, and in the boardroom. So I wanted to start by asking you, and I know I can't see you putting your hands up or anything, but how many of you have avoided conflict and hoped it would go away? And how many of you perhaps have wished you could resolve an issue that you've got in the workplace today, have it resolved, as I sometimes say, by midnight? So I know that we've got a quick poll for you there, if that could pop up now, to ask you your own responses on that. So here's the poll. Would you rather parachute jump for the first time, eat bush tucker bugs, or tackle a difficult conflict issue or conversation? So a quick vote there. And I know it's first thing in the morning to be thinking about eating bush tucker bugs, or in fact jumping out of an aeroplane, but let's see what people vote. So do we have any scores on that? So we'll wait for that to pop back up, but so we'll wait for that to pop that up, but the answers to pop that up. But what I want to talk about is this window of opportunity. So when conflict arises, sometimes we think that, you know, it's going to take a long time to resolve, but actually what we have is this thing called a window of opportunity. From the moment the conflict first arises, which I talk about as something like a tension, there's some kind of tension in the air, some kind of tension in the relationship. Moving on, you know, that then develops into some kind of conflict. There are definitely some conflict behaviors and some issues. And then finally a dispute, a deadlocked situation, which ends up going perhaps in an employment case into a grievance process, or it ends up perhaps in some kind of litigation. So what I really want to talk about this morning is, you know, why do we avoid the early warning signs of conflict, how this conflict escalates rapidly, and then why mediation can help, and perhaps why being a barefoot mediator can help as well. So avoidance, again, I haven't seen the results of the poll yet, but what I find in my work is that most people in the workplace, including leaders, have a tendency to ignore and avoid conflict. There might be early warning signs like breakdowns in conversations, and some of the other warning signs might be things like silence, staff starting to talk behind other people's back, withholding information, sabotage, and then you can get some sort of sometimes of sort of verbal assaults and so on. But if conflict's not caught early, it escalates. So that this avoidance thing tends to lead on to a process which I call escalation. And I do have a slide here for the escalation process, if it's possible to put that back up on the screen. So I talked about being on the escalator of conflict, and I wonder how often you in a conflict yourself have found that it's escalated rapidly. And I was thinking of a partnership dispute, for example, where it might start with one of the partners feeling sidelined or ignored by fellow partners, but once and the ability to have the conversation is broken down. So right at the beginning of the escalation process here, you can see what happens is that people stop talking. So they stop talking, or they stop having an effective conversation. And then the second stage is that you get what's called forming groups. So that could be you just go and have a chat with a colleague, but you might get a number of other people on your side. So they could be colleagues, could be people at home, but you tend to form a group around you of people who agree with your perspective, with your point of view. Then the next stage in this escalation process is starting to create stories. So obviously, you know, when we form a group, we create a story amongst us about what this conflict is about, and what's right and what's wrong. And those stories can sometimes get embroidered. And then the next stage on the escalation ladder is what I call threats or actions, actually taking some action, having some behavior which escalates the conflict. And sometimes that can be lodging a grievance, sending a letter, which you might regret later, or starting some kind of formal process, maybe litigation. Now, what's interesting as you get to further down the ladder of escalation is that the final two stages end up being not very much about what the original issue was about. And as a mediator, I see this often. Often it's about saving face. And the final step is called into the abyss together. So the parties or the people involved have forgotten what the original issues are. And now it's much more about, I don't mind if I go down as long as you go down with me. So you can see from this escalation process that right at the top, it's green. It's an easy to manage the conflict at that stage. We might say you were still in a win-win zone, but as you move down, it becomes much more win-lose. And finally at the bottom, everybody's going to lose. So this is why it's so important to catch conflict at a really early stage or involve someone who can help de-escalate the conflict. So that's great. We can stop sharing the screen now. Thank you. So that's the process of conflict escalation. And the problem with that, of course, in today's world is that it's going to increase the time it takes. So you have something called cost control and cycle time. So it's going to increase the amount it costs. The cycle time, the total time that it takes to resolve the conflict is going to be much longer. And both parties lose control over that. So they don't have as much control over the outcome. So the question then is, at what stage could mediation or the skills of mediation help some people with some of these sort of post-COVID issues resolve conflict? And the answer is actually the sooner the better. You don't really need to wait to use mediation or mediation skills to be able to solve these kind of issues. The sooner you start that process, the better. So conflict is seen as a process. It is the process by which people express their unhappiness with a situation or with other people. And if you see it as a process, you need to have a different process to be able to start the process of resolution. And my advice to businesses always is, have a conflict resolution process built into your business and make it part of your business processes. So I've got 3 steps here which I would advise businesses to have. One is to have a plan or a blueprint which sits within your business strategy and your processes for effective conflict resolution. And that should allow you to have several stages that people know they can access, which are 1, early and effective conversation, 2nd, some kind of facilitated dialogue, and 3rdly, mediation where you need that. And it should be very clearly delineated where you can have face-to-face conversations, and perhaps staff need some skills or some effective training to be able to have those conversations. Facilitated dialogue, again, can be using a third party, but perhaps someone from within the organisation, or again, perhaps a mediator, but who's coming in on a less formal basis to do some conflict coaching or to help facilitate the dialogue. And finally, a much more formal mediation, which is the kind of thing that the mediators who are on the screen today do. And then the final step of those 3 is to make conflict part of your corporate culture. And then the question is sort of, where does mediation fit now that we're not face-to-face? Where does it fit in the new normal? Well, most of us in ArbDB chambers have become very familiar with Zoom mediations. And the reason I'm called the barefoot mediator is that I mediated a case this week. And of course, you know, we're only from the top up, aren't we, when we're mediating? So I haven't been wearing shoes for most of lockdown, so I've become the barefoot mediator. You can go to mediation without your shoes on if you're a mediator. But the point about that is that what I found is that being on screen, whilst you're not face-to-face in a room, just offers some advantages. And some of the advantages for clients are that they can be a bit more relaxed. They can be at home, they can have their favorite sort of coffee mug with them. They don't need to sort of dress up in a suit and go to a lawyer's office. So the lack of formality and the fact that they don't have to feel that tension of being in the same physical space as someone that perhaps they're not getting on very well with can really help the process. And the mediations that I've done online so far, I've found to be really, really effective. So, and the other thing about that is that instead of having to set aside a whole day for a mediation, you can do things in smaller chunks, smaller spaces of time, because you're not having to set aside time and rent some office space and all give up a day. So it gives you more flexibility and a more relaxed atmosphere, and I'm finding it to be very effective. So really then, I'd just like to summarise what I've said. Instead of avoiding conflict, which is our natural tendency for many of us, it's important to catch it early, see it as a process, remember that escalation model and see it as a process and catch it really early. Remember then how quickly conflict escalates and know when and how you could use mediation and also mediation skills. And many of us in mediation chambers can help with that process of conflict resolution skills as well as actually mediation. So my final comment is mediation really is, I believe, the best business tool for the 21st century, and it's a process that makes really great sense from not only a business perspective but also a social and human perspective. So as you get back to work and post-COVID in what we call new normal, I'd really advise you to think about having some kind of mediation process built into your organisation. Thank you.
Thank you very much, Jane. Now we go to Sheila Bates, who is also Chambers member. Sheila is a CEDA accredited mediator and is an international dispute resolution professional, facilitator and trainer. Sheila is particularly interested in cross-cultural and workplace and employment disputes. Sheila will be looking at handling the emotional side of employment disputes. So Sheila, over to you.
Thank you. So good morning, everyone. So just building on what Jane was saying about the opportunity to mediate up in that escalation when you're at the green point, when it's easy to engage and have a conversation, often people don't. And the reason that they don't is because of their emotions. If we think about what's going on at the moment with COVID, with Black Lives Matter, with the questions of democracy in Hong Kong, we're living in a very emotional world. And those emotions may be fear, uncertainty, what's going to happen in the future. It could be hope, it could be great. You know, we're finally going to do something about climate change, great possibilities. It could be a feeling of gratefulness, the kindness of people, simple acts of kindness, or indeed gratitude to the government for having had this furlough funding. And probably for the scientists, it's really exhilarating, chance to shine, to do something fantastic in terms of creating that vaccine. So there's a lot of emotion around, and we've probably been a lot more aware of it recently, and it's been legitimized in a way because we're all feeling a lot of those emotions. So when you look at the business scenario, Jane was referring to bringing people back to work, how people are feeling about coming back to work. Maybe they're frightened. From a commercial perspective, looking at the time and the resources that you have, how are you going to keep your business afloat? Does that mean that you may need to make people redundant? Does that mean that you're going to have to cancel some pupillage training contracts? Are you going to have to, you know, make long-standing employees redundant? And how do you feel about that? And those are business imperatives now. And yet there's this gnawing feeling, oh my God, how will I deal with those emotions? So emotions are there and they are important. They're important for all of us. And I think you probably ignore them at your peril. You often hear people saying, let's leave emotion out of it. Well, guess what? You probably can't. So far better to recognize it and embrace it. And there's the emotion that you feel as an individual, and there's the emotion on the other side. And both can be causes for concern. So when you think about emotion, there's a nice little definition of it, which I really like. It's called energy in motion. And it's really interesting to be able to harness that, to harness joy, to harness relief, to harness anger, to harness frustration for better outcomes. So used effectively and engaging with emotions can really help creativity and can help find better solutions. Now, there are three important things I think about emotions, and that is that you kind of feel it in your tummy. There's this physiological thing in your tummy, you feel it. You can hear it in the words that you say. I'm really frightened, I'm really happy. What will happen if we have to close? And also things that you're thinking, because a lot of the time there's this internal dialogue going on. Oh my God, if I actually make that person redundant, what are they going to think about me? They're not going to like me anymore. And, you know, if I have to tackle that business issue, am I going to be credible? Am I seen as credible at the board? So there are a lot of core concerns behind emotions that make us, that are really important indicators of what's going on for people. So you really should ignore them at your, don't ignore them, ignore them at your peril. And the other thing about them is that they drive behaviors. So if you all had the experience, or many of you had the experience of your stroppy teenagers slamming the door and leaving the room because they can't go to that party, or because they're sick of being in lockdown, or they're sick of you nagging them about cleaning their room, you probably don't appreciate them banging the door. But as a parent, you'll be aware that, guess what? There's a lot of emotion going on. There's a lot of frustration. And generally as parents, you try not to rise to it. We don't always succeed, but generally you have some understanding of the situation. And recognizing emotions in ourselves and in those that we're dialoguing with is really important. So how am I feeling? You know, right now, I've had a lot of problems getting my Zoom up this morning. How's that making me feel inside? How's that going to affect the way that I'm going to present? How are the people on the other side looking at this another Zoom screen? Oh my God, here we go again. So what are people feeling on both sides? So recognize that in any conversation, difficult or otherwise, that there's your emotions and the other person's emotions. And often it's our own emotions, our own fears, our own concerns that block us. And so one of the things that mediators do is to recognize those emotions, and they're skilled at doing that, and to respect those emotions. You don't have to agree with the way somebody behaves, but that behavior is driven by an underlying concern. And right now, actually, they feel the way they feel, and you can't judge that feeling, it just is. So take a step back and then respond to it. And a really good way to respond to the emotion is to actually name it and actually say, I get the sense you're really disappointed we're going to have to cut that program because we don't have the funds. Or I see that you're really worried about having that conversation with that staff member. You might even share your own vulnerabilities. And by actually labeling that emotion, you legitimize it because that's the way the person feels. But you also gain a better rapport with them. They see you as a human being. And at the end of the day, we are all human beings. And you have to deal with the emotion before you can deal with the facts. Because an emotion is really a flag for something deeply important that often hasn't been attended to. So if you look at some of the stuff that's going on at the moment, why are people so outraged? Because Black lives do matter, that I need to be included in society. That's important. Why is Boris Johnson calling on his experts so much at the moment? Because Boris really wants to be liked. And if there's any hard decisions, well, it's really the science that's deciding that, not him. And so these are core concerns that we all have as human beings, and understanding that those exist and recognizing them and playing with them in a supportive way can really help move things forward. Now, I'm just going to tell you a very brief story. It's a real life story. And I call it Smelly Feet. And it's a story, it's a real life story, and it happened in an office that I was responsible for, a big office in a very big capital city in a major European country, fabulous office, really, really hot, about 35 degrees. And you get a knock on your door from your staff member and they say, you know, I'm pregnant. Yeah, I know you're pregnant. That's great. When's the baby due? Well, let's not worry about that right now, but let's worry about the fact that I am feeling absolutely nauseous because Tom's foot odor is so noxious that I just can't come to the office anymore. I'm going to have to work from home. So you're landed with that plate and you have to deal with that situation. And I'm going to ask Martin to just put up a little poll and ask you how you'd feel about that. So would you feel comfortable in having that conversation? No problem. I'll tell Tom he's got to wash his feet. It's got to be done. God, it's so embarrassing. Where do I even start? Or let's be smart. Let's delegate it to HR. Or to be quite honest, just like Jane, I'd rather parachute for the first time. It's less scary than having that conversation. So we'll see what the results and votes are on that. But I would hazard a guess that many of you might be trying to delegate it elsewhere. Perhaps you've got a manager who could really do with a bit of practice on difficult conversations. And the difficulty and the issue that this manager had in communicating this was they knew that there was an underlying medical problem. They felt deeply embarrassed about it. This was a key person. They didn't want to upset them. And so it took a lot of effort to have that conversation. It was had in the end, and a resolution was found. However, the majority of people I see on the poll are saying, it's really embarrassing. Where do you start? And that's about your own emotions much more than the other individuals. So I think recognizing the emotions on both sides of the table, really, really important. And in terms of the world that we're living in at the moment and what needs to be done, I think it's really important to understand that emotion is there, that mediators and conflict coaches can help you intervene early. So right at the early stages of the escalation, that you can actually have those conversations, call in a mediator to help you with process, call in a mediator to give you some coaching around how to have that difficult conversation. It can be done. You know, think about also in the final analysis, if there is a requirement for a mediation, if there's really a dispute, that a mediator, one of their skills is being able to recognize the emotion and to work with it for better outcomes. So I think it's over to Tony.
Thank you very much, Sheila, for that talk. Some interesting issues there. I want to first of all pick up on poll number 1. The result of that poll, if you remember, the question was about any increase in new employment disputes during the pandemic. And the answer to your poll was that the majority of people have not seen any increase in new employment disputes. So, Anthony, I'm coming back to you. Do you think that's surprising, or do you think that's to be expected? And what would you say about what's happening there?
Well, I don't find that surprising because, you know, most people have been away from work. And my general impression is, although I only talk obviously to limited numbers and probably limited types of employment or workers, that works reasonably well. What I do think is likely is that when furlough comes to an end, or as people go back to work, then there will be maybe a rise in disputes. Perhaps things have been boiling up while people have been away. So I would imagine that question might see a different answer in 2 or 3 months' time.
I mean, we've seen, Anthony, quite a few large-scale redundancies announced in the papers in the last 2 weeks. So how long do you think that, I mean, will that start to cause the sorts of disputes you were talking about?
Well, it could well, and that will be a little bit down the track, because most of those will now be in the process of consultation.
Yeah.
That will run its course, and then we could see claims in respect to consultation, what I explained at the beginning, for protective awards. It's possible. They're not that common. I think most employers are relatively well schooled in collective consultation, and it's probably not that difficult to get it right. More likely, I would think, would be individual claims from employees, for example, saying they've been unfairly selected, or they've been put in the wrong pool, or there's been some flaw in the engagement with them. And then that would be, you know, unfair dismissal claim, or perhaps a discrimination claim, or whistleblowing.
Okay, thank you, Anthony. Jane, the result of your poll, we didn't manage to get it during your address, but the vast majority, surprisingly, said they would tackle a difficult conversation. 40% parachute jump and 10% eat bugs. I mean, do you find that, do you want to comment on that?
Well, it's less usual, you know, it may just reflect who we've got on the call today. So what I usually find is that the majority would rather avoid the conversation. Some people don't mind jumping out of a plane. Most people don't want to eat bushsucker bugs, that's for sure. But it is usually the case that the majority would rather avoid having to deal with conflict.
Do you think people are being honest in the answer? Perhaps we shouldn't cast aspersions on our audience, but anyway.
Well, no, I'm sure our audience are being honest, but most business people say that they'd rather put it off till tomorrow, frankly.
Yes, yes. Now, picking up on that, I mean, picking up on your talk about the various phases of escalation, from my perspective, I think it's very difficult to, having managed a group of lawyers in the firm, to see when the stage changes from your first stage to your second stage. I mean, how do you recognize, you talk about the window of opportunity, but very soon, do you not get into that second stage of stories and so on? And how do you? You
do, and that's the point about having this sort of conflict resolution process built into your organization, because if there's an understanding that conflict's something which is normal and natural and is going to happen, and that everybody at every level of the organization has a responsibility to manage it early, they're all accountable for that, then instead of them all taking it down that stage, instead of starting to form those groups and so on, their responsibility and actually their natural tendency then would be to say, to take it to the stage and to take it to somebody and say, have a conflict, to have an issue, and to know what that would mean. And it would generally mean, you know, some kind of early intervention, some kind of conversation, but they should then have the confidence and the skills to do that. And that's why that process is so important.
When you say they, I mean, that would usually, in a fairly large organization or even medium, would be the HR department, would it not?
Well, it would, but I'm talking about every level. So even sort of, you know, more junior members of staff should have an awareness that conflict is accepted around here. It's normal, and that if I have an issue, you know, not to be what you saw called sort of, you know, continuous complaints, but if I have a genuine issue, I should have the confidence that it's okay to raise this issue and that I know what the process is. That doesn't mean I have to go straight to lodging a complaint or a grievance. And I think sometimes in organisations, what I've seen is that people collect their issues, they collect them in a sort of little black book, and they wait till they've got enough to say, now I've got a great big complaint. And it's much better to tackle these things early than say, well, now I've got something that can be taken to HR and can form a complaint or a grievance. And that's part of the problem with the mindset we have in many organisations.
Right, thank you, Jane. We have a question for Sheila from Michael Cover. Sheila, Michael says, we begin to understand that modern slavery is much closer to us than we in the UK thought. How might mediation work in these rather extreme cases? That's a difficult one for you, so
Yeah.
I'd like to comment on that.
Thank you very much. You're absolutely right. It is very close to us, and mediation can absolutely help. One of the key concerns of people who are victims of modern slavery is fear of retribution. They are frightened. They are very, very, very scared. And so having some remedy for those victims you can use the mediation skills to have some almost restorative justice, and it's very important to do that. With respect to tackling modern slavery, if you look at the recent Leicester cases, there have been many of them, and for those of us who work in modern slavery, it's not surprising, very sadly, is that very often the suppliers of the product to the next person up in the supply chain are very frightened to engage in conversation because they may lose the business, they may be delisted. We've seen what's happened to Boohoo in terms of their share price. So there are real concerns about what will happen if you whistleblow and raise the issue of modern slavery. In any long run, we all have to deal with the modern slavery, and actually working together using the facilitation skills and mediation skills, making people feel safe, helping to communicate the difficult messages that actually the supplier is going to, there probably will be slaves in their supply chain. You know, how do we deal with it? How do we work together? And helping the retailers, the people further up the supply chain, to actually partner and engage to find creative solutions to what is really a hideous and egregious crime that is very much alive and kicking. So those skills are absolutely vital. And very recently I had an example related to actually a large farm. And on this occasion, it wasn't actually so much about modern slavery. That wasn't the problem. The problem was that COVID-19 was introduced by seasonal workers. And the net result was that that potential farm could have been delisted as a supplier, taking the business down completely with massive reputational risk. And in fact, the opportunity to get in there and have facilitated conversation has really helped the situation. And hopefully things will go forward positively. So actually getting in there, recognizing the conflict, the concerns, the fears that people have, and using the skills of mediation are really, really helpful and productive.
Do you have anything to, thank you, Sheila. Jane, do you want to add anything to that? Or
it's not particularly my area of expertise,
no.
but I mean, I think what Sheila's highlighting is, you know, is very relevant, that there are opportunities, and so, you know, and these are things that we're seeing in the newspaper, you know, actually these kind of stories, but there are still opportunities in the background for us. You know, it's not what we would think of as conventional employment mediation, but there are still opportunities for us to use our skills to help people have the conversations. And, you know, businesses are at risk there, you know, as Sheila says, of being delisted. So important areas of work for us all.
Right. Jane, we've got a question for you from Nigel Campbell.
Yes.
The question is, if a company embeds a process of conflict resolution in its culture,
Yes.
might it not encourage employees to resort to the process rather than resolving disputes between themselves? So going into a mechanistic or a mechanical sort of process rather than.
Yes, I understand that, and I think
Yeah.
yes, within the culture it shouldn't be a culture of whining. So you don't want to sort of encourage a culture where everybody's complaining about everything. But hopefully, if the organisation has the right approach and culture, that wouldn't happen. But the first step should generally be that you would expect the employees to be able to perhaps have a difficult conversation with the other person that they had an issue with. So to perhaps have their own skill set, or to be able to have some coaching from an HR person, but to have a face-to-face conversation. So that should be the first step of that process, is a face-to-face dialogue between two people who have an issue with each other, rather than it being escalated to someone else. And HR should be within that process, able to support that process and perhaps support the skills that are needed.
Right, thank you. I don't think we have any more questions from our attendees. Just going back to the whole question of redundancies, there is going to be, in firms that are quite small, even barristers' chambers and so on, where redundancies are made, there's quite a emotional problem, not just for the employer making the redundancy and the employee, but there may be feelings among the continuing employees. Is that one that Sheila or Jane, you could comment on how you cope with that?
I'll go first. Absolutely. The way that you say goodbye to people and the way that you handle a redundancy can have a massive impact on your organisation. So you may have worked with colleagues for a long time. The smaller the organisation, the greater the sense of loss. In terms of, if you're 10 people and you lose a couple of people, well, effectively you've lost 20% of your resource. So the impact is on a practical level. It's also with colleagues, that they feel sad. And their work is disrupted. So actually, as an employer, being a good employer, handling the redundancies with care and with compassion will be seen by the other employees as making the best of something which is not a wonderful situation. Making somebody redundant is not the thing that we all wake up in the morning dying to do. So I think it's really important, and I think it's about engaging with staff also, in terms of the fears and the questions that they may raise. They may be thinking, well, it's me next, so there will be fear there. So I don't know if Jane wants to add to that.
Or Anthony, perhaps.
Yes,
Jane,
I agree with Sheila that, well, in many workplaces, even if you're in a larger workplace, the smaller team might feel as though they're a family in a sense. So you've got to understand the emotions that may be going on within the team as a whole, not just the person who may be made redundant, but as Sheila says, the people who may be left behind, and dealing with the whole of that, not just the difficult conversation with the person who's to be made redundant. I think sometimes if that is an awkward conversation, and if it's got over too quickly, then you haven't dealt with how could you help the person who's being made redundant? How can you help everybody to deal with that situation without creating more tension, if you like, which often is the unexpected result.
Anthony, do you want to add to that?
I very much agree with what Sheila said. It's something which I've talked to clients about quite a number of times over the years, making redundancies, the impact that the way they handle the process will have, not only on the people who are going to go, but the people who stay behind. And this issue comes up with enhanced redundancy payments. The statutory scheme isn't generous. I think the cap on a week's pay is now £538. Had it kept up with inflation, where it was originally set, it would be way in excess of that, might be 2,000. So large employers will often have enhanced redundancy schemes, but smaller employers will sometimes make enhanced payments, in part because of the message that sends to the people who remain.
Anthony, another question's come up from Dave Owen. He would like some comments about voluntary redundancy and how that works.
Well, Yeah, thanks for that, Dave. I mean, a lot of redundancy, you don't have to have allowance for volunteers. It's not a necessary ingredient of a fair redundancy scheme. It's an advisable step in the process. And the important thing is that the key thing is that the employer doesn't hand over the decision to the workforce. So if you allow people to volunteer, it needs to be on the basis that they apply to be made redundant. You may or may not accept them, but in practice, of course, once someone's volunteered for redundancy, the employer knows that person wants to go or is happy to go, provided he gets paid the money. And normally, in my experience, volunteers are accepted, within reason, but not always.
Okay, Sheila or Jane, do you want to comment on voluntary redundancy? No?
Not particularly, no.
My only comment is that very often the best people may often opt to volunteer to leave, and from an employer perspective, and in training talent, that is something definitely to think about, because people, often your best people who may be easily employable elsewhere, may be the ones who'll put their hands up, and that may be the talent you want to retain.
Good point, thank you. Well, on that note, we're approaching 10 o'clock. We don't have any more questions at the moment, so I'm going to draw proceedings to close. Thank you all for attending, and thank you to our 3 speakers.
Thank you.